Welcome to Daily Dispatch. Today, we're breaking down the unprecedented legal battle involving former President Donald Trump and the U.S. Supreme Court, unpacking the arguments, the stakes, and what it means for the future of presidential accountability. Before we get started, if you're new here, don't forget to subscribe and hit the notification bell so you stay updated on all things law, politics, and current events. In a recent development, attorneys representing former President Donald Trump have brought their case before the U.S. Supreme Court, alleging that special counsel Jack Smith has misrepresented the case against the former president. They voiced concern over the prosecutor's push for a speedy trial and urged caution, asserting that the petition for writ of certiorari before judgment should be denied. Smith, in his prosecution, has raised the question of whether absolute presidential immunity extends to crimes committed while in office. Trump's legal team countered this by emphasizing the president's assertion that immunity covers official acts. The criminal case accuses Trump of attempting to overturn the 2020 election results. The legal backdrop for presidential immunity was examined, referring to the 1982 Supreme Court opinion in Nixon v. Fitzgerald. This case established absolute immunity for presidents in civil suits related to official acts, aiming to shield them from personal legal actions that might compromise the presidency. The current legal battle, as argued by Trump's attorneys, is unprecedented in the 234-year history of the United States. They stress the significance of the question before the court and oppose an expedited review, highlighting the ongoing consideration of the case in the appeals court. Addressing the issue of double jeopardy, the defense refers to U.S. District Court Judge Tanya Chutkan's ruling that impeachment proceedings and subsequent acquittal don't preclude criminal charges. Trump's attorneys counter that unless a president is impeached and convicted by the Senate, criminal prosecution is barred. The defense team contends that allowing criminal prosecution for official acts of former presidents would set a dangerous precedent, citing examples of past presidents accused by political opponents without facing criminal charges. The case has taken a turn with Trump filing motions to dismiss on various grounds, including the presidential immunity defense. The rejection of this motion in the district court led to an appeal, with the special counsel petitioning the Supreme Court for an immediate review. Prosecutors argue for a swift trial in the public interest, while the defense alleges a rushed schedule to interfere with Trump's re-election campaign. Adding complexity to the legal landscape, Alabama Attorney General Steve Marshall and 18 other state attorneys general question the necessity of a speedy trial, suggesting partisan motivations. Former Attorney General Edwin Meese, III, and law professors Stephen G. Calabrese and Gary S. Lawson submit an amicus brief, raising questions about Smith's jurisdiction to make such a request. The legal saga continues, with the first appeals court hearing scheduled for Jan. 9, 2024.